go from there.
You know, some attorneys on this podcast, I feel like I have to drag stuff out of. Some of them are like walking billboards for the importance of great legal service and advice. Jen Sawday, I met her actually on, I think it was a LinkedIn post or LinkedIn group, really lamenting on how bad, or how unprofessional many real estate agents were, and it kind of got my attention. You're right, let's raise the standards. What do we need to talk about? And really one of the things I like about her is she's so clear on the mistakes that are made and gives us some practical advice on how we can move forward. So Jen Sawday, partner TLD Law in Long Beach, thank you for joining us again on the podcast. So let's go to the very beginning of the topic. I asked you a question. I got some great material. It's too bad we record the pre-record, but funding the trust. You know, so many people make a estate plan of some sorts, including a trust. It's kind of like buying a safe deposit box, and they bring the safe deposit box home and they wheel it and put it in a safe closet, but they forget to put the stuff in the safe deposit box. That's pretty much what an estate plan without funding the estate plan looks like, isn't it?
Yeah, so when you open up the trust book, just because we list bank accounts and property, it doesn't mean that it's in the book. We have to look at the bank statement. And so I had a client just now, what do you mean? Well, if you bank at Bank of America, bring me the statement. Let's look on the top. Look at the vesting of the bank account. Does it say that it's in the trust on top? And if it doesn't, you have to call the bank or go in. Same thing with credit union, Vanguard, wherever you have money. Just because you put in your book on a schedule, oh, this is in my trust, or you make a note, it's not. You have to confirm it. I spend so much time arguing with clients. You've given me no proof. Have you gone to the bank? Does the bank have they've ever seen this book? No. Did you ever put it in the car and take it to the bank? No. Well, then the account's not in the trust. Right. And all you're doing is creating a nightmare for your loved ones later. Bank accounts are easily fixed, though. You can go online and call and go in. But property is another one that we need to talk about.
Well, before I get banks, it's easy to fix ahead of time, but afterwards, it's a nightmare to get them. At least in my experience, I have customers who have Wells Fargo, Bank of America, and they want the actual letters, they want an actual wet signature stamped approval if it's a probate case, for example. If it's in a trust, that's a whole nother, trying to convince them to do their job is difficult. And so I think that people may underestimate how difficult it is when you need the money is when it's important, right? It's not about upfront. Let's talk about, though, in addition to funding the trust with bank accounts, real estate, because as a realtor, the classic is I pull the prelim, I meet the customer, I say, hey, by the way, Jen, I noticed you hold the property as Bob and Jen Smith. Have you guys considered an estate plan? Oh, we have one. And they run back and they get this beautiful notebook. It's about, I don't know, about that thick. I don't know if I can get it on the camera, about that thick. And you open up the nice Naugahyde or leather notebook. There's tabs and pages. Oh, here's the paper the attorney told me to get done, which is what deeds the property in the trust. It's not filled out. It's not signed. It hasn't gone to the recorder. Classic case of not funding the trust. Talk about the problems that creates for people who maybe have a trust but haven't put the property in the trust.
Yeah, and real estate even more so. When you look at the deed for the real estate, it has to mention the exact name of the trust. So my husband and I have a trust. It's called the Donald and Jennifer Sawday as trustees of the Sawday Family Trust. So if you pull title to my home and it says it's owned by Jennifer and Donald Sawday as trustees of the trust, that's incomplete. You have to put the name of my trust. Well, first you have to name the trustees. But the actual name of the trust, you can't truncate it, you can't use initials, you can't shorten it, and you have to put the date. And if it's missing any one of those, the title company, the county recorder, or the assessor is going to put their hands up and say, this property is not in the trust. So now I've got to go to court to solve it. But when you're alive, we can fix it. Right. Today alone, my 9 o'clock and my 10 o'clock appointment both came to me with properties that they thought were in the trust, but the trust name was incomplete. 2 in a row. Blew me away. 2 this morning. So now the clients have to hire me to fix the deeds because they're still alive. So they're taking it from their name into the fake trust name into the proper name. So when they do pass away, they can show intent to put it in the right trust name.
Oh, I realize if they deed it into the wrong trust name, then the wrong trust name has to deed it to the right trust name. Yeah. And that can be challenging with title insurance, meaning even though you can deed it and record it, when it comes time to insure the transaction, the title company still might say,
Title, this is the same trust. It's like this morning there was the Roger and Mary Ann trust, and they put it in the R&M trust. There is not a single person in this world in terms of title, real estate, and the assessor and the recorder that's going to say Roger and Mary Ann is the same as R&M. You have to match the trust name. So however you've named your baby, you're stuck with it.
and I find, particularly in California where I operate, that there are two types of estate plan attorneys or services. One, where they do it for you, right? And not to say that attorneys don't make mistakes or that paralegals don't make mistakes, but by and large, they get done, the deed's done, and some even record it, which I think is really important. And then it's all done. And there are other ones who say, well, you're going to save a lot of money, but you have to do the deeds on your own. Or you'll save the money, and here's the deed. Go ahead and get it notarized and recorded. And, good luck getting that done. And I find so many of those people are ones that come back to me as a real estate agent and say, oh, well, it didn't get deeded. It's no big deal. We can just get they'll learn the term Hegstead petition. We can just do a petition to put it in the trust. Well, it's not like, going online and ordering from Amazon to get a trust. It's a whole, so talk about, imagine a trust was done improperly. What does the after the effect process look like to move it from outside the trust to inside the trust, commonly in California, a Hegstead petition?
We're having a hard time convincing the court in LA County that it's the same trust. The court may just say, I disagree with you, Miss Sawday. Let's talk about an interesting fact. So the Dodgers won the World Series, right?
Yes.
Guess what's not open today?
Oh, the court closed. A lot of courts.
All the hearings that I had set today in Stanley Moss in downtown have been
Yes.
punted.
Me too.
So I'm going to get minute orders tomorrow or later this week. So all the probates that I had going on today, boom, gone. Going to court is not an absolute. When you go to court for a Hegstead petition, my hearing days in Orange County are about 12 months away. It's not an emergency.
Well, say
My
it
hearing
again.
days
Say it-
in
say it
LA
again.
County is about 6 months away.
So say it again now. That's a critical piece because people say, oh, it's no big deal. You can just get a Hegstead petition. Yeah, you can get it if you get the hearing and get it approved. In how long in LA and Orange County? 6 and 12
It
months.
depends on where the property is, but the different courts have different deadlines and time periods. They don't consider a dead body owning property an emergency. There's no rush, not at all.
Right.
So this goes back to the point is if you have a trust, check title, or ask your agent to pull title, pull the deed, make sure everything matches. And if the deed is not in the trust, then go back to your attorney and get it updated.
Yeah, and this is also a case for the real estate agent as soon as you list a property, right away pull the preliminary title report. It's usually free if you're working with a good title rep. I've interviewed some on my channel, and there's just no excuse not to get that ball rolling. You're going to need it, and it has information on it. And if it's wrong and needs to be corrected, the earlier you start, the better off you are. Because again, you can't just get a Hegstead petition. It's not like ordering a box of Cheerios on Amazon. You got to get it ahead of time and get it done in a timely manner.
I mean, when you talk about wrong, today I had to clear a probate note in a trust matter where we spelled the name Ann wrong. So instead of being A-N-N-E, we spelled it A-N-N, and our hearing's been continued. So everything is so important. But the whole point is that if you're alive and well, double check, and let's do the cleanup now. The mistakes that I'm fixing aren't mine. They're from someone else. Everyone has good intentions, but you've got to keep on it. Your chain of title needs to be smooth, no blips.
I had a real estate listing in probate, a big commercial property where the father and son had the same name. One used the middle initial, often one didn't. One used junior sometimes and not all the time. And so you had a deed from father to son, and that was the contest and the difference between a deed versus a probate. And if it was a probate, it went to other relatives, and if it was the deed, then the son got everything. So you're talking about millions of dollars over an initial and junior, not junior. And it wasn't consistent throughout. And obviously it could have been resolved and money spent on attorney's fees. Not that we don't like paying attorneys, but you'd rather pay them for planning than for correcting deeds after the fact, right?
Yeah, I mean, people actually don't mind paying my fees because they understand there's a problem. They can't handle the weight.
Right. And you can't speed it up. You can, but you really can't. I mean, there are little things you can go to court early on, but in general, the probate process is going to take the time it's going to take. It's just, and nobody's happy with it. Like no customers ever said to
Right.
me, wow, that was great. That year and a half I spent in probate was like the best year of my life. I learned so much. I enjoyed it. I've never had that experience. Okay, one of the things I want to get to before we kind of go back to the beginning with you, Jen, is you have, I feel like you're really one of the thought leaders that I look to. I read your posts on LinkedIn, I read your blog posts, and I always learn something. I think that, for somebody who's in this business and wants to be an expert, you must be constantly educating yourself and learning. And I don't know the law. I learn it from people who study it like you. Recently, you had a great blog post, and this really hit home to me personally. It's on your website titled "Why Your Health Insurance's Advanced Healthcare Directive Isn't Enough." And what it's saying is that, let's say you're a member of Kaiser, or in my case, my wife is a patient at Cedars-Sinai. So we have our own estate plan with health directives that we worked on intimately. And then when I was in the hospital with her, and I discovered, she, without me knowing, signed some health directive that Cedar provided. Now, good for Cedars that they make people have one. That's a good thing. I guess good that she signed one. I guess that's a good thing. But now all the work we put into ours doesn't really apply. In your blog post the point you make, one is that if you're, let's say you're in the Kaiser system and you do one, and then for some reason you need medical care at some other facility, they may not recognize the Kaiser health directive. So in essence, you don't have one at all. So talk a little bit about the importance and what people should do in their planning process.
Yeah, when I meet with clients, they want to save money, right? So they want to knock off my drafting list. My drafting list is long. They want to knock it off. They think if they cross off something, then they're going to save $100 or $500. And so one of the things they always want to cross off is, I don't need a healthcare directive because I have one.
Right.
I said, great, where is it? Open the book, show it to me. Oh, it's lodged in the portal at Kaiser or
Right.
Cedars-Sinai.
Right.
No, you don't have a copy. It's not out.
Right.
The healthcare directive isn't just for your doctor at that medical facility. It's for any doctor anywhere where you may get sick or injured. You may not get injured at home. You might be in Vegas, you might be in Hawaii, you might be on vacation, or you may get airlifted and go somewhere else. But also, the healthcare directive is not just for that doctor. It's for any doctor that might be treating you, an orthopedic surgeon, whatever, right? But it's also used to give to crematoriums and funeral homes to make funeral arrangements. They need to see it too. So if you pass away and your healthcare directive's in someone's portal, no one can go back and print it out and say, I'm the agent.
Right.
So we want to do one. Now, with medical decision-making documents, you can have multiple documents. They can work together. They don't have to cancel each other out. So you can have one inside your portal, but you still need a standalone where I can take it out, whip it out, and use it. You just don't know.
Well, I also had the opportunity to download mine that we did with our estate plan and send that to Cedars in my wife's case, and they have it, and then they'll use that one. That would be ideal. And the other thing is that, the health directive is one in particular I'm aware of, but all these legal documents, there are often important legal changes that come up. And just because you went to Kaiser 10 years ago and did a health directive may not cover important medical changes of the last 5 or 10 years, or legal decisions last 5, 10 years. So I guess the question is, obviously when you get married, divorced, somebody dies, new children, you have to redo your estate plan from a financial point of view. But isn't there also kind of like a legal process where maybe every 3 or 5 years, enough laws probably change that you should redo it anyhow? Is there some of that as well? I never hear attorneys really talk about that.
Yeah, there was an overhaul for durable powers of attorney for healthcare in 2006. So California changed to the advanced healthcare directive model. So if you have what's called a durable power of attorney for healthcare, in theory, it's not valid anymore, although your hospital may still take it. So if it's older, you need to have a new one. Yes, you need to keep track of your changes every time. Usually, we want your healthcare directive now to be a permission for you. Otherwise, if you have strong feelings about things, then we can put in there how you feel about nutrition, hydration, end of life. But in the beginning, if you're alive and well, we just want permission. The right people to make decisions for you in the right order.
Right.
It's easy to update. See, the thing that I'm seeing right now, there's this lady, she came today at 10. She was cute. I go, where's your stuff? She pulled out the smallest purse I've ever seen. And she whipped out a folder here. And then she whipped out another folder. And I go, how much do you have in this purse? And her husband just burst out laughing. It was like a clown car. And she kept pulling out documents and documents and documents. And she had a big stack in this tiny little purse. I said, lady, you need to staple everything, punch holes, and organize it. She had old documents from the early 2000s. She had late documents from last year. She had documents that were duplicate. You got to organize, put it together, throw away, because you don't want the kids to pick up the wrong set of documents. You need to make it easy.
Right.
And I'm finding people just don't organize their own documents themselves. They're afraid to punch holes now. Everything that we do with the course, we scan it in. We're no longer blue backing, no longer sending in the originals. So just hole punch, put it in a binder. 4 tabs: trust, will, power of attorney, healthcare directive. And then you can have another tab where you have all your schedules of what you own in terms of assets, what you own in terms of insurance, maybe passwords, crypto, whatever, all the useful information, put it in your book.
So, how much of this now is being moved to online? I mean, in the rest of my life, everything I have is online. The only documents I have, though I have them scanned and saved and a direction given to a key person, are my estate plan, and I have a friend who I'm his successor trustee. And I'm thinking, there's got to be some way out of this. Do you still require customers to have a hard set, and that's the primary set, or has it moved to online, or do you see it moving to online at some point?
Yeah, you want a hard set, because if something happens, the first responder is going to come into your home, right? You're going to call 911, you're not feeling well, that paramedic is going to come in, they're looking for that book. They know what it looks like.
Right.
It should be on the bookshelf on the down. They want to open it up, and call your wife, call your son. All that stuff's in there. They know what they're looking for. If it's online, the first responders can't find it. You have to print out this document. You can do both. You've got to have it.
I also imagine being in a hospital, God forbid, I'm having some sort of major medical problem. What's your Google password, Bill? It's, I mean, really, how would you possibly, I don't know about you, but I have a master password, so how drugged up would I be, and then I can't come up with a master password, and then everything's locked up. So all the online stuff isn't really available.
You got to look at how we work as a society. You know, something happens, you call, someone comes running in, it's a stranger. They want to be able to figure it out. So my dad died in 2001, and he had a heart attack. He had called 911 the minute he had the heart attack. So the ambulance broke into the home. They broke into the bedroom window because he had a list of emergency contacts. My mom had already passed. Here's my daughter's number. I got a phone call right away.
Wow.
Your dad's on the ground. We're going right to emergency. I was able to fly out of bed and go. I mean, he died, but they knew.
Wow.
And I had gotten married. I wasn't home anymore. I saw him maybe once a week. So it wasn't a case of a missing person. You have to make it easy. And online is only easy for you. It's not easy for anybody else.
Right.
You have to have some paper.
That's a good point. I've seen people really push having everything online, and I feel like it sounds good, but I just know at the wrong time it would be impossible to get access to. I mean, even for me especially, because at the same time, all this is important information, I'm trying to keep it secure. So on one hand, all my bank account numbers and passwords and all that, I keep secure. On the other side, I want the right person to access it. I guess it really has to be in paper. There's no other way to do it.
You don't have to put your bank account numbers in there, but you can name your bank. You can put the last 4 digits or the last 2 digits. You can put in that document where the account numbers are. There are things you can do.
Right.
But you don't want to hide it, because when you hide it, I can't find it later. Because I tell the client, somebody passed away, bring me a list of what they have. These bank statements don't come in the mail every month anymore.
Right. They really don't. Most people don't get them anymore. I can tell you as a real estate agent, I ask you all the time for a statement of the mortgage. They don't get them in the mail anymore because all these companies want to be all electronic, and it creates some security issues. Being able to access it, a third party being able to access it, is not the same. So I know I asked you this on the last time around, you just mentioned it in passing, but it's not a coincidence that you specialize in probate and estate planning. This is something you got into. You mentioned at your time of your father passing. This is something you got into around that time as far as specializing. I mean, you're an attorney, you have a license to do all kinds of legal work. You're really hyper-focused in the trust and probate space. Was that what triggered it? Was your father's passing? And talk a little bit about that
Yeah,
experience.
my mom died when I was 21. It was in 1993. And then I was 28 when I lost my dad. They were both young, 46 and 52.
Wow.
And when my dad died, I didn't know enough because I was still in law school to say, Dad, you need to set up a trust. I just didn't know. So we wound up going through probate. And so back in 2001, before 9/11, we really didn't have email. We were using AOL, Instant Messenger. So I would visit the attorney every month and sit and fill out papers. And I saw the process. And so what's really interesting is the attorney that I hired back then, he was in Wilmington, and he had a lovely paralegal, and her name was Norma. And over the years, I had always remembered how kind they were to me. And last year, Norma came and hired me to handle some of her estate planning.
Wow.
And once I saw who she used to work for, she just broke out in tears. She goes, Jennifer, I remember you. I helped you with your dad's probate, and now I'm helping her with her trust.
Wow.
What a world. So it's a blessing to be able to do what I do.
Wow.
Having gone through probate, I can help you go through it mechanically. That's what you want. You want me to be organized, efficient, and go. But probate's exploded. Our firm had one paralegal before COVID that helped me with the cases. They helped all the partners. Now we have 6 girls that are
Mm,
helping. People
mm.
are not getting their plans together.
No.
They're
No.
not.
Well, I think there's two things. One is there people are not. I mean, obviously, more people are older, more people are dying, elder stage. Also, I feel like the system has gotten more particular. Like some things used to slide through, like on this hex petition. Some of these deed things, the county just recorded them, the title companies just recorded them, insured them, and nowadays, with all this technology, everything's gotten a little more particular. I think even I've only been in this field for 6 years. I can see the county attorneys are much more particular when they look at filings and procedures than they were even 4 or 5 years ago. And so that's also part of it is doing on your own. Like you can do it on your own, you just can't do it on your own. Is kind of how I look at it, right?
Yeah.
How many times do you get people come to you try to do it on their own and they're just like stuck in the mud?
Yeah. And you know the legal Zoom trusts that I see, they send them to you in a really nice binder.
Mm,
And it has a zipper.
mm-hmm,
They're black. And they just want to put your name on it. And it
mm-hmm,
says Sawday Family Trust.
mm-hmm.
So they bring them to me. And every time we uncrack it and go, and we open it, it hasn't been signed. It hasn't been notarized.
Correct.
It's just people, they get these zipper binders. They never bother to open it. They think they're done.
I think 80, I heard a statistic, 80% of online trusts are never executed, let alone funded, not even executed, which means somebody paid, they saved a lot of money because
I
they only
know.
paid $1,000 instead of 5,000, but what they end up with is a collection of paper, which really isn't worth anything if the decedent passed away already, right?
Yeah. And I get so mad when I talk to my clients about funding because when I see them, I can tell they don't understand it. Sometimes I get so mad, I leave the room and I grab one of my paralegals and I say, get in here and tell them in your words how to fund it.
Right.
So now they're listening to my paralegal. And
Nice.
Brittany, who's the one I use the most, she says, you don't understand. Jennifer's trying to teach you something. This is how it works. And she says it differently. And between my conversation and Brittany's, they go, oh my God, I got it. They take the book and they go to the bank. I spend so much time in these meetings educating. And until I see that light bulb, we're going to hammer it home until you understand.
Right. Right.
It's crazy.
It is hard to understand, and people just don't get it. You know, I have a client who passed. He had a $40 million estate. He had gone to estate planning attorneys several times. He wrote some very big checks, but he never finalized the trust and never funded the trust. And so now I don't know the amount of legal bills. I imagine it's $1 million, $500,000, somewhere in there, between various attorneys, all types of attorneys, to move the assets, sell the assets. There's contests in the assets. And so, again, the book is really pretty and nice, but you're not paying for the book. You're really paying, I think, for the relationship and a
Yeah.
clear plan. And then you need to kind of look at the attorney as the coach on how to execute the plan for your estate plan. So, yeah.
Yeah. It's interesting. The funding can't be done by me unless it's the business, real estate, or a promissory note. I can do assignments and deed work, but bank accounts, you have to go to the bank. If you have your
Right.
money managed by a financial planner, he or she can contact me and we can work together. But
Yes.
your accounts at Wells Fargo, Chase, the big banks, and the credit union, you have to go in.
Right.
You have to take the book. You have to go.
Right.
And it's hard. But once we kind of get through all that, they finally get it. I tell them, try bank number one, get a sense of the process. Everything else will fall through.
Do you prepare the deeds for the real estate to fund the trust, meaning when they own property personally and you create an estate plan, do you create the deed from Bob and Mary into the Bob and Mary Trust? Do you get it
Yeah, I
recorded?
do it for California real estate. If it's out of state, then we need to talk about it. If
And
it's timeshares, we need to talk about it.
do you get it recorded as well?
I do record it. We since July of 2020, we do online recording. We're one
Beautiful.
of the few attorneys that we could just set it up, get it back in an hour, and it's in the trust.
It's beautiful. It's a beautiful
Yeah,
process. And I
and
don't
if there's
know,
something wrong with the legal description or the APN, they'll tell me right away, and I can fix it.
I've done, I don't know how many interviews about trusts and estates, and I've had attorneys explain to me why they don't want to do it. And I have to be respectful. And people run their own business, so they're entitled to make those decisions. But for me, I would never refer a customer to an attorney that doesn't prepare the deed and then record the deed. And then, like you mentioned, if something's wrong, correct it and get it recorded. Because to me, that's what they're paying you for, right? They're not paying you for the book. And they're not paying, as nice as you are, Jen, nobody's paying for your time. They're paying to get their assets funded so that when they pass, everything is taken care of. And I appreciate you saying that. Let me walk you through that. But I think it's really important. Anybody watching, and as a real estate agent, all the more so, I'm expected to be a professional if I refer to somebody. Not only that, I can go online and verify the recording because we have access to public
Mm-hmm.
records. And I find customers appreciate it, attorneys appreciate it. Hey, I noticed that you went to Jen, you got your estate plan done. I see that your deed was recorded. Here's a copy of it, even though she probably gave you a copy of it. It's also reflected online, which I think people want to know that.
Yeah.
And so for us as professionals, and I know my conversation you started about realtors not being professional, this is a standard that we need to meet. And I do think that if you're going to refer somebody to an attorney, that's a minimum standard. They should fund the trust all the way through to the end. They should not leave that in the hand of the customer who doesn't know what the heck they're doing.
Yeah, but you're also, in a sense, paying for my reputation. See, at the end, when the title company gets my trust, they
Mm,
know that I vetted everything. Oh, Sawday
mm,
drafted it. Oh, TLD
mm,
drafted it. Good.
mm.
And the same thing when someone passes away and we do the trust admin and the activation, you take it to the bank. Vanguard, oh, I know the firm. F&M, oh, I know the firm. Good, 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 good. Right? So you're paying for that. So it's
Right.
good. You should hire the trust attorney near you. If you're
Mm,
in San Francisco, you shouldn't be hiring me. I'm in Southern California. I want you to drive to my office, sit in front of me, and I want to open everything up and go through everything together. So just because you might be watching this and thinking I'm, the best, fine, but you've got to be local to me. It will
right.
help you.
Right. And just for the record, you're located in Long Beach, in beautiful Long Beach.
Yeah, yeah. I'm in Long Beach. Yeah, I'm by the Long Beach airport. So
Very nice.
anything in LA and Orange County, if you live here near me, come here. We can help you.
Right.
Yeah,
Conveniently off the 405 freeway. I used to work in an office in
yeah.
Signal Hill, so I know the area real well. So let's talk a little bit, kind of as we wrap up, a little bit about collaborating with real estate agents, because this primarily my channel is very heavily real estate agent focused. I'm a realtor. I want to learn how to work better with attorneys like you. We need to think about probate cases as opposed to estate planning. So something kind of went wrong or wasn't done, and now we're managing the probate process, and there's real estate to be sold. What are one of the two best practices that you've seen the really good realtors do? And maybe one or two mistakes. I know you have a long list. What are one or two mistakes you've seen realtors do that prolong the process and make it more difficult for customers?
Yeah, so it's hard with real estate agents. I have my few that I love to work with. I tend to pick the right agent in that property area to handle. Most people come to me with an agent in mind or the agent that's the introduction, so I keep it.
Right, right,
But you have to run title ahead of time.
right.
So last Thursday, I had a client come in. I have to open probate. My wife died owning this property. And I said, great, show me the deed. Oh, I don't have it. The agent has it. So I called the agent. She didn't pick up. That was on Thursday. No return call Friday, no email. I don't have the deed. The
Wow.
reason why I don't have the deed is because the vesting was done in 1977 and it's not
Oh,
online. Somebody has to
right,
go in and pull it. I know he has it at home, and I know the agent has it because she pulled pre-rem because it's co-owned with the sister. But no one will give me the deed so that I can say, well, what's best? Is it joint tenants? Is it tenants in common? How is it title held? Is it still in the parent trust? Where is it? I can only do so much. You have to come to me with that information. If you have an agent and you are the agent, equip your client with that title report. Bring it to me.
Right.
Don't hide it.
Right.
Yeah, it's
Yeah, I think
hard.
it's really important. I think one of the things we provide as realtors is the information. And yes, they can get it from other sources, but being convenient with it is part of the opportunity we have. And so I always feel like I can pull deeds online. And what you mentioned, the older deeds, yeah, it takes 2 or 3 days for the research department to get them for me. But at least I start the process and I'll get it in 2 or 3 days. And I think that's
Yeah,
all anybody can really ask for.
yeah, yeah, yeah.
So best practice, pull the prelim. In the process of selling the property, I always say it's never a problem until it's a problem. In most probate cases,
Right.
the vast majority are full authority, meaning there's not a problem if somebody objects. And yet sometimes people do object, and then now you have a little bit of a problem. So what are 1 or 2 best practices or mistakes you've seen made when we're selling property that makes things worse as far as a conflict?
Well, we can sell property easily in a probate. That's not a problem. What makes things worse is that people don't understand that property taxes are going to go up.
Mm.
So I've made this sign to take pictures with the clients now. I know it's backwards, but it says property taxes will go up. Because I tell them, I've told them, I've sent them a letter. So now I'm going to say, just take a picture. You hold it up and we'll take a selfie because property taxes are going to go up. And they
I
don't
love
get
it.
it.
Yeah.
Like over the weekend, I'm arguing with the client. Oh, I moved into my dad's home that I inherited. Your dad didn't live in this house. It was not his primary residence. He lived elsewhere. Here's the letter that you signed a year ago that says property taxes will go up. You got the bill this morning. Thank you, Jennifer. I understand. They keep forgetting. And it's hard because I want all of you in the real estate space to tell me how to tell the clients to remember.
Right.
Property taxes are going to go up. There's some exclusions, but it's very few. That's where the problems come is later. They're issuing that, what you call that, supplemental tax bill after the property's been sold. And they think in escrow, when they get the deduction for the prorated, it's at the old
Right.
rate.
Right.
That's what's tripping everybody.
Right. They think they're done because they sold the house. And I've had that happen many times where they get the assessment, and the assessment goes back to date of death, right? So it can be, in some cases, a couple of years, 2, 3, it could be longer in some cases. But if it goes back 2 or 3 years and they've owned the property a long time at a very low rate, that new rate would apply for maybe 2, 3 years. It could be thousands of dollars. You're not talking about hundreds of dollars. You're talking about usually thousands of dollars. So very important. Okay, and then do you get much into an estate planning from a tax perspective? I mean, I'm not sure really where the attorney kind of ends and the tax attorney or accountants kind of step in, because obviously we're in California where we have mansion taxes, we have changes on the exclusions on property taxes, we have just like never-ending threats of increased taxes. How do you get involved in the estate planning as regards, minimizing taxes or tax strategies? How important of a part of your practice is that?
Yeah, well, there's multiple taxes. So property taxes, there's no strategy there. There just isn't. If I had a strategy to sell you, I would. There just isn't. Capital gain taxes depends on whether or not you've inherited the property and you get a step up. So it's often better to sell mom's home after she dies instead of just before she passes. And then estate taxes is becoming a non-issue for most of us. California doesn't have an estate tax. The exemption amount for the government in terms of the federal government is going to be $15 million per person next year. So if you don't have that kind of money, we're not paying an estate tax. But with capital gain taxes, we need to talk to your tax person about that. And with property taxes, I can walk you through that.
It seems like oftentimes, mom and dad leave a house, there's 3 kids, and the choice is either divide the house 3 ways, or then they're going to sell it, or give it to one kid and then have them cash out the other ones. And the kid who keeps the property then might get the exemption of property taxes, and might get the exemption on the capital gains, but the distributing 3 ways, you're for sure going to get reassessed if you keep the property. And so these are things that at the time, is this something that you define when you do the estate plan, or do you kind of create does a trust create for you the opportunity to make those decisions,
Yeah,
at
that's
the
a
time?
tough one. If you have a house and you have 3 kids and you want one kid to get the house, your trust should be drafted that way. Billy should get the house as part of his equal share, or Billy gets the house first. You have to give an out for the assessor not to reassess. But in theory, the assessor wants to make sure that if you're saying 3 equal shares, that you have enough money in the trust. So if you have $1 million house, you should have 2 million in the bank.
Right.
So each kid gets the value of $1 million. The house to one, $1 million, $1 million. If you don't have enough money in the trust, then the person who's the trustee needs to get a hard money loan or an equalization loan.
Right.
And that is a deep dive into a very complicated area. When people inherit homes after people pass and we're worried about property taxes, the county says you have 1 year to fill out the form and move in and make it your primary residence. When people pass away, a year goes by fast.
Right.
You have to come to me right away if that's what you want to do. If you come to me a month before the expiration of the 1 year date of death, I'm not going to help you. I need time to get my act together. That's a
Well,
tough one. Yeah.
shameless plug on that deep dive. I created a new podcast called Fractional Interest, and I've interviewed a couple attorneys who are in that field. I don't know if that's something you'd like to. We can talk about maybe offline if you're interested in being a guest on. But again, I think this is coming up more and more often because you're talking about a lot of money. If you're talking about not getting that equalization loan, you're talking about taxes on $300,000, $500,000. It becomes real money for people who have the right strategy in place. So again, shameless plug, Fractional Interest Podcast. Wherever you get your podcast, look for that coming out soon. Jen, look, I kept you a little over. I so appreciate. I always feel like I always learned so much. When I started this podcast, my criteria was as long as I enjoy talking to it, which you're a pleasure, and as long as I learn. I feel like I always learned so much from you. I hope today those who are paying attention learned from really one of the leading attorneys in Southern California on these matters. Jen, if someone wants to get a hold of you, I have your website. TLDlaw.com is the company website, and then your personal information down below. Is that correct? And then there's your blog, which is really good. It seems like you do about another post once a month or so. I would say it's bite-sized. Can read in a few minutes. Definitely worth checking out. But there is Jen Sawday under Our People. Thank you so much for your time, Jen. Really appreciate it.
Yeah, thank you for having me. It's always a pleasure. Yeah.
And for the rest of you, this was Probate Weekly. We get together every week and interview most commonly probate attorneys, trust attorneys, talk about both how to avoid probate and what to do best. If I can help in any way, please reach out. I'm at Bill Gross Probate on social media. And as always, make today your best day ever. Thank you.